Assalamu alaikum and good evening, ladies and gentlemen. Honorable Justice Mr. Zafar Ahmad Jatruth, Honorable Justice Mr. Muhammad Abdur Rahman, Ms. Patricia McKellar, distinguished guests, respected members of the legal fraternity, Provincial Head of the United Nations Resident Coordinator Office, representatives of the business community, ADR practitioners, faculty members, students, ladies and gentlemen. On behalf of SZABIST University, we extend a very warm welcome to all of you. Today, we gather for a very special occasion, the launch of the Center for Mediation, Arbitration, and Conflict Resolution, followed by an insightful panel discussion, Turning the Tide, Reimagining Justice through Alternate Dispute Resolution. This initiative reflects our shared vision of a future where disputes are resolved not through prolonged conflict, but through dialogue, understanding, and fairness. To begin our program, I will move towards our opening remarks from Ms. Patricia McKellar, the Dean of the Laws Program, University of London. I would invite you to share your thoughts with the audience.
Good afternoon. It gives me great pleasure to be part of this launch event today for the Centre for Mediation, Arbitration and Conflict Resolution. The establishment of this centre reflects a recognition of the changing landscape of dispute resolution in the world, not just in Pakistan, but in the world. Litigation has long been the primary mechanism of resolving conflict, but it's increasingly evident the courts alone cannot bear the burden of every dispute, and litigation cannot always deliver the most efficient and equitable, or indeed sustainable outcome. ADR has emerged as a vital complement to traditional court-based adjudication. It offers processes that are more accessible, less adversarial, and often more effective in preserving relationships. It's an opportunity to resolve disputes through dialogue rather than division, and cooperation rather than confrontation. I think it nurtures a culture of respectful communication and problem solving. Establishing this centre enhances the credibility of the discipline in SZABIST, Karachi and Pakistan, and it will do this by contributing to the intellectual development of ADR through rigorous research, comparative study and critical reflection. It also has the opportunity to provide experiential learning opportunities to prepare the next generation of lawyers and mediators to approach disputes not as contests of power, adversarial contests, but as problems to be solved with creativity, fairness, and integrity. You know, I can think back to when I first started teaching law, which I have to say now seems in another life. But in the vocational course that I was teaching, we offered mediation, and it was instructed by trained mediators. Students loved it. They loved the whole concept. They totally embraced it. But when they got out into practice, their seniors and the lawyers they were working for were not really that interested. Mediation hadn't developed at that point. It hadn't developed enough or been accepted enough to provide a lasting solution. What's more, if the case didn't go to court, there was a fee implication which was not particularly attractive to the lawyers. It's a very different picture now, with many jurisdictions now embracing some form of ADR in their legal systems. In UOL, University of London, where I come from, we've championed the development of ADR as an area of study. In fact, I think sometimes we were a little bit ahead of our time. We actually introduced a module on ADR about 7 or 8 years ago. We're a huge program, as some of you will know. And on our modules, we have up to 5,000 students, but we would expect a minimum of about 500 on some of the optional modules. We launched an ADR module, and you know, we couldn't even get 50 students on it. And we actually had to discontinue it. During COVID, we discontinued it because it just wasn't viable. But with the encouragement of the Pakistan Bar Council, we launched a short course in mediation skills last year, and over 400 students have logged into these materials. It's a short 6-week course with interactive resources. It's accessible at any time, done at any place. And the course at the moment is actually being transferred to become a University of London micro-credential. So in other words, a short course where the students will get an assessment and a certificate at the end. But what's more, this September, again with the encouragement of the Pakistan Bar Council, we've launched an ADR module within the degree programme as an option to students. And it covers all the ranges of the legal, theoretical and regulatory foundations of ADR. And hopefully this centre, which we're launching today, will provide more opportunities for students on this module and on any other module where ADR is relevant to deepen their knowledge and practice in the area. This centre will not only enrich the academic life of SZABIST, but will also make a meaningful contribution to the legal profession and to society at large. I look forward to watching its progress and to its shaping conversations on how we resolve dispute in the 21st century. I wish you all the well. Thank you.
Thank you, Ms. Patricia. I would now like to invite the Vice President, Administration and HR and Acting President, SZABIST University, Mr. Imtiaz Qazi, to share his thoughts.
It's not every day that you are in the presence of a galaxy of legal minds. And what a pleasure it is. Thank you so much, ladies and gentlemen, for coming to us and be part of us. It's a great encouragement to us and to our students. Excuse me. We understand from the reading of history that the dispute resolution is perhaps as old as human civilization. In one or the other form, humans have settled their disputes. Of course, with the establishment of judiciary, it was institutionalized. And then we got this dispensation of justice. I remember way back we read in history that in subcontinent, it's a centuries-old institution of panchayat, centuries old. And we have inherited that in Pakistan and India also. But the institution of panchayat is old, where these disputes used to be settled. I also remember from reading that if somebody who was found guilty by the panchayat, then hukka band, hukka pani band was the word used for that man. That means he is socially ostracized. Nobody would talk to him. Nobody would shake hands with him. So hukka pani band was a great, great punishment at that time, which used to come through panchayat. On the upper layer, of course, we had the jirga. The jirga system, unfortunately, has become very infamous, and it has degenerated into a system which is lethal to women folk. So therefore, it has earned that notoriety, although it was a good system, and it can still be a good system, provided its repulsive sections, repulsive practices are excluded. I believe I come from civil service, and I have participated in jirga systems when I was serving in tribal areas, and even sometimes presided over them. So anyway, it's a closed chapter. Okay, this center we expect and we hope proves to be very, very beneficial to society, and we would hopefully get recognition from the High Court, and that we will be able to dispense justice and provide relief to the people, relief which is inexpensive and which is prompt. Your presence has been a great blessing. You would not realize how beneficial and how encouraging it is to us and to our students. Thank you so much once again.
We are privileged to acknowledge the following distinguished individuals. Mr. Ehsan Ali Ansari, please come up on stage. Ms. Shadab Hizbullah. Oh, my apologies. Please be seated right now. Because we have to proceed with the certification distribution ceremony first of these individuals, and for that I would like to call upon Ms. Patricia McKellar on stage, Mr. Saad Wasim, Mr. Imtiaz Qazi, and Dr. Altaf Makati. To present our accredited mediators, we are privileged to acknowledge the following distinguished individuals. Mr. Ehsan Ali Ansari, Mr. Shadab Hizbullah, Ms. Ms. Shadab Hizbullah, Ms. Rumala Sumro, Mr. Samad Raza, Ms. Larib Abbas, and Ms. Rabia Khan. Thank you so much. But I would like to request Ms. Patricia McKellar and Saad Wasim to please stay back and receive the token of appreciation. From Mr. Qazi.
Moving forward, we now come to one of the most anticipated segments of today's event, the panel discussion. Before we begin, we would like to take a moment to introduce our team. Under the leadership of Ms. Zainab Effendi Haqqi, Head of Department at SZABIST, we are proud to launch the Center for Mediation, Arbitration, and Conflict Resolution. The center will be led by Ms. Maham Jamali, whose vision and dedication have been the driving force behind this initiative. In line with this, we are delighted to announce our upcoming accredited mediation training program, a 40-hour training course to be conducted through SZABIST under this center. Today's panel brings together respected members of the legal fraternity, academics, and judiciary. The discussion will be moderated by Ms. Maham Jamali, founder and head of Center for Mediation and Arbitration and Conflict Resolution. Her leadership and commitment have been instrumental in bringing ADR to the forefront of Pakistan's justice landscape, and we're honored to have her moderating this session. She has represented Pakistan at the Asia-Pacific UN headquarters, promoting women empowerment and peace building through mediation and conflict resolution.
Thank you so much, Hafsa. So dispute resolution lies at the very heart of justice. But today we ask, must justice only mean litigation? Around the world, mediation and arbitration are reshaping how societies handle conflict. Today evening, we explore how Pakistan can turn the tide and reimagine justice through alternate dispute resolution. Therefore, I would like to invite our first guest on the panel, Honorable Mr. Muhammad Abdur Rahman of the Sindh High Court. He has been a practicing lawyer since 2001, where he has established himself as one of the leading litigators in Sindh before joining the bench in 2023. Then we have Alize Bashir, currently partner at Kabraji and Talibuddin. She has extensive experience working on contentious and non-contentious matters with a strong focus on litigation and dispute resolution. We will have us then Mahar Mustafa Qazi, partner at Ria Bakar Gillette. He represents clients in complex commercial disputes before the High Court specialist tribunals and in local and foreign arbitration and expert determination proceedings. And we will have in the last Mr. Ravi Pinjani. Mr. Ravi Pinjani is an advocate of the Supreme Court. Mr. Pinjani has been practicing law since 2006 and is the founding partner of Pinjani and Vadria. He also serves on the Legal Advisory Committee of the SZABIST University Faculty of Law. I'm so happy to have you on this panel. To start, Honorable Mr. Abdur Rahman, I would want to ask you, so there's a perception within the legal fraternity that mediation may reduce the role of relevance of lawyers in dispute resolution. So how can this skepticism be addressed, and how can the profession be assured that mediation in fact strengthens rather than sidelines their role?
Well, to begin with, I think that's been one of the most foremost challenges in terms of bringing mediation into any jurisdiction. To understand the role of a lawyer is to realize that it is, in the essence of it, it's a service. It's a service that you give to a client. And when you give that service, it's with the end goal that you wish to resolve the problem that they have. Now, one of the biggest constraints that we've had, and this has been through any system, is that whenever you make a system accessible, it'll overload. And when it overloads, that essential service that you were eventually supposed to be providing, you can't provide anymore. This is not something that's subjective to Pakistan. It's been the same anywhere in the world. And there are 2 or 3 solutions to this. One of the solutions is to impose heavy costs. And that's a model that's followed in some jurisdictions. Other jurisdictions, like the United States, have a more democratic approach to litigation. They say no costs, you have a right to litigate. Now, if you have a right to litigate, you're going to flood the system. The only solution that then comes about is, do we really need to go to litigation? And how do we encourage people to go into ADR? And that's where this divide comes in between lawyers and whether they want to become mediators or lawyers. To my mind, I really don't see the role of a mediator being very different to that of a lawyer, in the sense that they both are essentially providing that service which resolves a dispute. The lawyer's role in this is twofold. Firstly, and this is what's happening quite often all over the world, is that a lot of lawyers are becoming mediators. And the amount of work that they can deal with in terms of resolution of a dispute, in terms of time, is probably 1/10 of the amount of time it takes in litigation. So the volume that you can bring in terms of revenue should not be really impacted in that manner. Now, will there be opposition? Everybody is going to be afraid of change. Let's just accept that as it is. So what do we need? We need a lot of capacity building. Capacity building in terms of education. Capacity building in terms of education both of lawyers and of clients to know what options that they have. And then having capacity building in terms of lawyers actually becoming certified as mediators, so that they can take on those roles, fill those gaps which exist, and then move forward. So to summarize, yes, I think that there is this problem, but it's more about fear rather than any real issues. And if people actually sat down and actually looked at the real issue, you would find that there isn't really that much difference between what we're doing as litigators or as counsels in mediation. It's just be a bit more quick, and a person might get more encouraged to go into a system if it yields results. And that's the real issue that we need to do. We need to actually see that the system works. The other issue that you're going to have, and this is another issue that lawyers will come in, is enforceability. In terms of, well, you've got the mediation order, how do we make it enforceable? And that again is where lawyers come into play. So I do see there's a lot to do with lawyers within that process. Whether they choose to avail it is a matter which they need to come to terms with. And I know I've been working with the bar associations quite actively to develop that capacity so that we're able to bridge this gap. And I think we've done that quite effectively. I was just speaking to the president of the Sindh High Court Bar, and I think in the last 2 months they've certified 200 mediators, as lawyers as mediators. So it's coming.
My follow-up question to that would be, then do you think there should be a pre-filing stage, especially for the parties? Should the parties be made bound to do mediation?
Okay, that's a good question. So let's begin by trying to understand what we're doing. When you talk about litigating, you have a code of procedure. Now that code of civil procedure is, for us, it's over 100 years old, probably longer than that. To bring mediation within that procedure, you're going to have to make some pretty radical amendments to that. I mean, it's happened in other parts of the world. There have been 2 different approaches that have really been taken. One is basically pursuant to something known as the Wolf reforms, where they said, okay, we're not going to force you, but if you don't, there are going to be consequences. And those consequences are really in terms of costs. The other approach is basically what's going on in America, where you mandatorily have to go into mediation prior to going into court. And that has its advantages in the sense that before the dispute really starts, you're trying to make sure that all the issues are addressed within an open discussion rather than being constrained into procedure codes. So I think that a lot of it requires statutory intervention in terms of Parliament making a decision as to which way we want our legal system to go. And in that regard, we can just impress that and look at some of the statistics, and my personal opinion, at least in certain areas of cases, let me just give you some statistics which I know the president of the bar and everybody might not be aware of. In the district courts prior to the relocation of the original site of the High Court, there were about 65,000 odd cases, out of which 17,000 were family cases. That was nearly 1/3. If you're going to talk about it in terms of just the consequences of that on society, that there are 17,000 families in court at any given time who are stuck there, and which could probably be resolved if there was a mediation prior to institution. Now, I'm not saying that's a fail-safe, because some of the consequences in family litigation in Pakistan can be quite severe. And that sensitivity we have to take on board. But in terms of just making that a prerequisite before going into litigation, it might reduce that number tremendously. So yes, I would really think that that was something that you need to do.
Thank you so much. My question now is to you, Alize. So one of the biggest concerns in arbitration is enforcement. So how can we ensure that the arbitral awards and mediation settlements carry the same weight and reliability as a court judgment?
So at the moment, we already have certain efforts made, for instance, by the amendment to our CPC, which permits parties to go to mediation largely by consent, and for those mediation results or the outcome of that mediation to then be brought into court and be made effective just as a court decree would be. I think one of the biggest difficulties is the provincial bifurcation of the laws that can possibly allow for more concrete enforcement and for the encouragement of centers that actually are able to be addressed by the High Court or be accredited by the High Court to be able to bring those decisions in. So while we are having a lot of mediation trainings and people are becoming mediators, where we don't have one national arbitration center or arbitration and mediation center, for instance, the reliability on mediation itself ends up resulting in the mediation outcomes not being as successful as they could likely be. One, because where do you hold the mediation? In Punjab, there will be a different law, which will strengthen the enforcement of the decision reached by the parties. In Sindh, there will be a different law. And that then creates an ad hoc policy framework and ad hoc understanding of how you can actually go into that forum and be able to achieve a more productive and just as enforceable and binding decree.
Thank you. I do have a follow-up question. So you mentioned about not having arbitration centers. Do you think the state should institutionalize such centers, or should it be developed by private institutions?
So there's no one right answer, but institutionalization has seen to work in a lot of different countries. India has a national arbitration center. Bangladesh has an arbitration center. Rwanda, post-conflict, chose to establish one, really because the credibility of that institution and the funding and the support that it may receive from the state, which also then changes the culture of the state in encouraging arbitration and also following through with arbitration procedures with a little more seriousness. Because if we don't have state backing over the creation of centers like this, you have different levels of training, and that will affect the quality of the mediation that is being offered. And if that quality is not working out for a lot of parties or not achieving positive outcomes, then there is less likelihood that people will approach those forums. But if you have an arbitration center, you can also avoid mistakes that the government has made, including where it has chosen to go into arbitration, primarily in commercial matters. We've seen, for instance, the broadsheet case back in 2012, where NAB was thrown off by an award of $28 million largely because it was choosing to avoid the arbitration proceedings through which this award resulted. Trying to, or the modality of it was similar to how people approach the court system, seeking adjournments, not showing up, not making filings on time. And it was because there was no state-backed single policy support for what arbitration and mediation can possibly achieve. So I think the creation of a center could at least fortify the state's understanding and backing of this system, and that should encourage litigants as well as the entire, I would say, justice system in following through with it as well.
Absolutely. My next question is to you, Mr. Qazi. So, how do you see the international best practices influencing the local arbitration landscape, particularly with Pakistan's evolving investment climate?
Well, thank you very much. I think there are a number of clear signs where you can see the influence of international best practices coming to Pakistan. First and foremost, in the context of arbitration, the courts have led the way in developing jurisprudence that has upheld a pro-enforcement stance, largely relying on case law from other New York Convention countries to uphold arbitration awards and to preserve their finality, to narrow down the range of grounds on which the arbitration awards can be set aside. So that's one large manifestation we've seen so far. Something else that's in the pipeline is an arbitration bill which was put in place or drafted by the Law and Justice Commission of Pakistan last year under the leadership of Mr. Justice Mansoor Ali Shah of the Supreme Court. That proposes a whole new statute to govern arbitration and a unified statute whereby you'll have foreign arbitration as well as domestic arbitration governed by a uniform system that implements the UNCITRAL model laws. So the UNCITRAL is a UN trade body which came out with a model law on arbitration, which has been adopted by, for instance, by India in the 90s, and many of our regional peers have already long ago adopted that. What that gives you is a statutory recognition of the finality of awards, a presumption that awards are automatically enforceable unless they're set aside. It empowers arbitral tribunals to give emergency awards, to give interim relief. So all the avenues that prior to, during, and after arbitration for going to courts and having two-track dispute resolution, those have been largely narrowed. So that's one big manifestation. And the final one, I think, is the Singapore Convention that relates to mediation. Pakistan has signed that convention, but has made an important and notable reservation. They have excluded the applicability of the Singapore Convention on Mediation for disputes which involve the government. And most of the disputes in Pakistan relating to land will involve the government by definition. A lot of commercial disputes which involve regulations and regulators also involve the government. So you won't have mediation there, but then again it's one step and one manifestation of how international best practices are influencing Pakistan.
Thank you so much. Mr. Pinjani, I have a question for you. So with digitization, especially post-COVID, do you see online mediation and arbitration as realistic solutions for Pakistan? Or is it premature given access and literacy issues?
If you notice, the two processes involve a very different kind of engagement with the parties. Arbitration involves an authoritative determination, which eventually gets backing from the judicial system. But mediation is, by and large, voluntary. It involves, as a precondition, your desire to settle. And if that is not genuinely present, then a mediated outcome is almost impossible. So, given digitization, and digitization does create this gap between individuals while communication. So perhaps for arbitration, it will be an easier adaptation and it makes an already informal dispute resolution mechanism even more accessible if parties are sitting at different places. But as far as mediation is concerned, perhaps a greater interpersonal engagement is necessitated by and large, particularly in our society more so, where you can bridge the gap literally also by engaging with each other and exchange of ideas in a more proximate space. So perhaps digitization may not give us a material advantage with mediation, but certainly with arbitration.
So it's safe to say it's premature for mediation at least.
It's a technology, so you can use technology insofar as it helps you. If it doesn't help you, you won't. So in certain cases, it may really help you. So for example, mediation is not only limited to personal disputes. If it involves large commercial troubles, two companies sitting at different places can get into mediation through the digital platforms as well. So I wouldn't put it in black and white that it's not helpful for mediation, but there is this aspect of interpersonal relations that will be left out.
Thank you so much. Thank you. Sir, I have a question for you, Mr. Honorable Justice. So given that statutory provisions already mandate referral to mediation, how can courts strengthen compliance and oversight to ensure that such referrals are effectively implemented and contribute to easing the judicial burden and the backlog?
Well, when you talk about referral to mediation, I immediately get slightly worried. As Mr. Pinjani just stated, the concept of mediation is that it has to be voluntary. Now, if two people don't want to go into mediation and we force them to go into mediation, I mean, you're already on the back foot and trying to make it work. So the first thing that you need to do is to make sure that people are educated about what mediation actually is and the benefits of that mediation. So they're more willing to participate in that process positively. Now, once that is there are various issues, and I'd stated this earlier as well, in terms of capacity building. The advantage that a trained, qualified mediator will have is to understand that when you mediate, you don't mediate the position, you mediate the interest. And to identify that interest requires a bit of fact-finding. When you're on the bench, being able to understand what's going on behind is a bit of guess, but a bit of experience. And you're able to then understand what the interests of the parties really are to refer those matters to mediation. And I think that's the most important thing, the ability to make a distinction as between matters that need to go to mediation and matters that don't need to go to mediation. Because if you send the wrong one, you're just going to delay the entire process, which will again lead to a lack of confidence in the system itself. So in terms of judges referring matters to mediation, a bit of caution. First, make sure the parties want to go, and if they want to go, then make sure you send the right one. Because both can have a big impact on the entire confidence in the process. We have been working very actively with I think the terms of the judiciary in terms of mediation awareness is huge. There was mediation training for all judges in the district court 2010. And there's still been capacity building on those issues that are going on to date. So those are the issues that would occur. But the main thing that you would have at the end of the day would be the question of, if I refer it, who am I referring it to? Now, if I have 17,000 family cases and one mediator, how's that going to work? If I have 17,000 cases and 100 mediators, it's still not going to work. So there's a lot of capacity building that we're going to have to do, and I think the judges are very much aware of these issues, and they're proactively working. I know that the district judges are here as well. We've been actually working with the district judiciary to make sure that a certain amount of cases are referred to court-annexed mediation centers. and thereafter to make sure that the right cases are referred. So that's happening.
So essentially, the burden again lies on the judges.
No, I don't think it only relies on the judges. I think that, as I said, if there are 17,000 cases in a file, we have 2 court annex mediation centers in Karachi. One is at the High Court, one's in the District Court. I cannot possibly send 17,000 cases, or no court can send 17,000 cases to one person. How many judges am I going to be able to refer this to? And I'm going to make a very straightforward statement. I've discussed this with other people as well. If I have a court annex mediation center, which is for free, and I give a client an option to go to a court annex mediation center, which is a judge, for free, or to a lawyer certified as a mediator for a fee, where do you think they're going to go? So, you know, are we destroying a market? Are we actually turning around and saying, okay, everybody wants to go to the judge who's going to do it for free, and then overload that person to the point that the system collapses? So these things have to be taken on board at a very practical level. And again, we've realized this from experience. And again, the capacity building amongst the lawyers to do mediation will encourage referrals, which can then be dealt with expeditiously. The caveat on that is we need competent mediators. So centers that, like SZABIST, I believe IBA has also done it, are good. They will develop that capacity. Standards have to be maintained.
Absolutely. And we hope we also maintain the standard. Alize, so are there jurisdictions you think Pakistan should learn from, regionally or globally, in, again, institutionalizing ADR? And what lessons you think are transferable, and what challenges that are unique to Pakistan only?
One of the biggest difficulties is actually the quality of mediation and access to mediation. I think I'd also say from experience that when we have had court-referred mediations or otherwise, we have been met with exorbitant fees that, you know, mediators will be charging, which will discourage clients from going. We are uncertain about the quality of the mediation. There's obviously an uncertainty about how effective justice will be, where someone does not have the necessary expertise and to some extent the legal knowledge as well. So if you are now required to hire counsel, which just as Abdul Rahman had said, will still have a very primary role in advising parties as to what their legal rights are, so and to how to guide the mediation so that it can be successful. If you don't actually institutionalize the level of training, whether to mediators, you don't encourage parties to approach a center that can be reliable and that also has international recognition to that effect, there will be less of a systemic shift and less of reliability and trust in that system. What remains again very disparate between in how arbitration and mediation is being developed in Pakistan is that it is largely being centered around the commercial hub that is Karachi. And mediation is starting to take a very elitist context around it, and most parties are not willing to go, despite that a lot of civil disputes and family disputes, as we've just heard, are actually the bulk of the cases that are burdening our court system. So what happened in Bangladesh was that there were NGOs involved who actually sought to implement or support the legislation that had now required pre-action mediation or pre-action arbitration between parties, which of course serves as a deterrent before you go to litigation. The courts will review also the nature of the correspondence that has been exchanged between the parties. At the moment, we actually have confidentiality, and I'm not sure whether confidentiality is entirely required, because when you look at the nature of the correspondence and whether or not the parties have conducted actually genuine mediation is something that the courts then assess. And then the successful party or at least the losing party will suffer costs. So, if you don't have a holistic system, if you don't have a system that is backed by the state, a system that is accessible to everyone, whether you go into the interior and are dealing with a different nature of disputes over there, where are the mediators being trained, in more remote areas, and that then again will not result in a culture developing between amongst litigants as well. We are a very litigious society. People are, they love going into court for very small disputes, and most of the time it is pressure tactics, most of the time it is a misunderstanding of the law. If you are able to just get some guidance, and if there is a prerequisite to litigation that also involves a stage where you have been advised of your rights, where you understand how things are going to be, where you know that the level of involvement that you have in the mediation and the genuinity with which you carry it out towards the object of a positive outcome that is amicable for or helpful for both parties, I don't think we're really going to see much of a shift. But that said, we look at parties like India. I was looking at the ICC report for this year. India is a very major participant in ICC arbitration. You don't see Pakistan anywhere. And we've seen the outcome of international arbitration and how our courts, on account of, I suppose, policy and really just to avoid shutting down our country and our economy, were not amenable to enforcing or allowing for those awards to be made rule of court and impact the country the way that they could. So I think a lot of work is required, and institutionalization could help that. India has developed an app which largely deals with, so that's a form of ODR, following from what Ravi was saying. Some areas, yes, they could develop where you have the tech industry, where you have startup disputes, where you have disputes that really involves just an exchange of information and or facing the tribunal or facing the council is not absolutely necessary because of the nature of the dispute. Those approaches are very accessible. There's an app. Today, there's a lot of efforts being made towards digitization in Pakistan. And if we were able to develop apps, then that will deliver results based on concrete information delivered by both parties. Those are quick results, and then it is referred straight into court, which then makes that decision a binding decision, and it speeds up the process. So lots of initiatives. The UK also has a lot of ODR initiatives developing at the moment. But with all that said, I think being the country that we are, we still have a long way to go in terms of developing our literacy, our education, especially amongst the lawyers. I would say the quality of education that's being delivered and everyone's adaptability to a more institutionalized system is probably a still long way away.
Right. You mentioned about a couple of jurisdictions, India and Bangladesh. Do you think those lessons are transferable to Pakistan, since we are, again, South Asia, or we have our unique challenges?
Actually, that's a difficult question to answer. I think that the more, as I mentioned provincial bifurcation earlier, I think that will be difficult to achieve. I think our efforts towards education are far more limited than we have seen in Bangladesh and in India. Commercialization of those countries, their growing exports, international trade, that nature of disputes, I think has inculcated a better culture and a more promising approach to arbitration. Whereas in Pakistan, I think there are a number of changes that we need to see, both in training of lawyers, training of students, training of courts, as well as the mediation and arbitration systems that are developing before we can see any material change.
Thank you so much. My question to you is, Mr. Qazi, now that arbitration is often presented faster dispute resolution mechanism than litigation. But in practice, arbitration does sometimes exceed that of the litigation. So how can we strike that balance?
Yes, I think arbitration certainly in commercial disputes it is expensive. Right from the get-go, if there is an arbitral institution involved, you've got the client having to foot the fee not only of their counsel, but of the arbitral institution, of the arbitral tribunal, i.e. the arbitrators who will be there, of any expert witnesses who will be needed, fees for the venue also. So it is costly. And I think underlining all this is, we can't lose sight of the fact that litigation or the court system is the dispensation of justice, which is one of the foremost duties, obligations of any state. Arbitration is a private service, whereas, courts, litigation, that is a public good, and must, in order for you to have access to justice, you've got to, you're obviously going to have better affordability. I think to tie into that point, it's also important to observe that while arbitration can be more expensive, one of the reasons for that is something that can be addressed, and that is that under the current arbitration statute, the 1940 Act, there are very extensive avenues for court intervention. Pre-arbitration, when the appointment of the arbitrators, during the arbitration, following the arbitration. So there's multiple rounds, and it's basically litigation by another means. So if the UNCITRAL law is passed and your statute is overhauled, you'll at least reduce that and perhaps reduce the gap. Because when we measure cost, it's not just the monetary figure, it's also the number of years you take. If you can arrive at a final decision much sooner using the arbitration route, even though it's more expensive, it might remain a preferable choice regardless.
Thank you so much. Mr. Pinjani, I have a question from a very academic point of view. So coming from you as a practicing lawyer, what do you expect what role academia should play in bridging the gap between ADR theory and its practical application?
The academia can really play a very strong role here, because if we look at ADR has had the real difficulty is its acceptability as a means for a definite solution finding mechanism. Now, we in our universities do train the LLB students to think like a lawyer. And one of the foremost things about thinking like a lawyer is to stand for the rights of your client and to be the vanguard. Like a soldier, ke bas lad pado, uske liye pura karo. Mediation requires a very different mindset. From the get-go, even as a lawyer, you need to think, if a client has come to you, whether there is an easier solution to what his problem is. And to think of a person in that manner, कि यार मसले का हल निकालना है as opposed to winning a battle. This mindset is inculcated in a school best. That's the best place to inculcate that mindset. Not in a profession life where you've already more hard-crested and you're more difficult to change. Your approach is more monetary incentive. Is he a client? Is he my business? As opposed to, is he in problem and let's help him find a solution, because that's always a long-term best business policy in any event, that if you develop a reputation whereby you as a lawyer are solution-oriented, you'll get more business anyways. But that's something which is not easily appreciated. So as a university, you can, and that's the best place to train minds. So if that approach can be encouraged and taught at every stage of your education, whether that's in law, whether that's in economics or in business, that you get into a trouble, you find a middle ground, and until and unless that medium is exhausted, don't go into litigation. And if you go into litigation, keep a door open for still finding a solution. And that's a mindset approach.
My follow-up question would be, now with the 4-year LLB degree program, mediation is a course, But would you say that arbitration should also be included as a mandatory course? For
Mandatory
LLB?
or not, it's definitely a very good elective to have for any student of law, because as Mehar really laid it out, it's the most efficient and long-term cost-effective means of getting a dispute resolved. And one of the major ways of why it's so efficient is because it has one forum finality. So the arbitrator's award can be shaken on very, very limited grounds. But in a judicial system where we have not only one right of appeal, but two statutory rights of appeal by and large, and then if the litigation is starting at a lower forum, then we have the revision, writ jurisdiction, all the way to the Supreme Court, the matter goes. So if you look at the age of litigation, because of the levels of regulatory oversight, which is very important in a way because you're talking about rights and rights alone. Whereas arbitration is about getting you a final answer to a dispute. It's not so much about whether your right has been vindicated, but more about whether you have, by agreement, reposed confidence in an individual or in a tribunal. You've got your answer, now you live with it.
Thank you so much. Moving on to the last question for all of you. So Pakistan has recently seen growing interest in ADR, but the uptake remains limited. So what is this one policy, legal or institutional reform recommendation that you would recommend to the industry? So sir, if you could start.
I think the main one is to make a very clear decision as to which way you want your legal system to go. And that has to be legislative. Either you go down the cost model or you go down the pre-mediation model before litigation, but that has to be statutorily introduced. That is probably the most important decision that this country really needs to make. And it has to be done uniformly throughout the country. I mean, if I have it in Pakistan, in Sindh, but Punjab is doing a different model, then you're going to be shopping for where you're going to go. So this has to be uniform throughout the country. So that's the main one as far as I see.
So I think I'd echo what Abdur Rahman Sahab is saying. But I think what we need to, place a very strong emphasis on is the quality of disputes and the nature of disputes that are coming through. And I think the general public needs to have a lot more awareness building about how their disputes can be resolved. That also includes information and education on their rights, to actually know what outcome there is. A lot of times they are either poorly advised or have poorly advised themselves as to what their rights and entitlements may be. I think that will really encourage a growth towards ADR as well.
Thank you. Mr. Ghazi.
Yes, I think the single most important measure, it has to be a legislative measure. I echo what Mr. Justice Abdur Rahman observed. I think the problem isn't that arbitration is expensive or that people don't have enough awareness of mediation. You can resolve both those problems, but you will still not have uptake until you remove the incentive to litigate. The system we have now does not, fasten a party that that initiates litigation not as a dispute resolution tool, but as a dispute management tool to freeze a dispute until something or the other changes. And then that case goes all the way up to the Supreme Court, and the Supreme Court finds that this was frivolous all along. There's absolutely no consequences, but you've frozen a dispute for 30 years. Unless there is you change that, and unless there's a disincentive to do that, mediation can never become win-win, because the current understanding with litigation, where it's sort of adversarial and winner takes all and zero-sum game, that has to be addressed, I think.
I echo the opinion here about costs, but there is another angle to costs, and by and large we do think of costs as coming as a penalty from the court for wasting the court's time, but it ought to be also compensatory, because many a times the winner does not really get compensated for even the cost that he has incurred in getting the outcome that he gets. And so the legal fees, for example, lawyers are getting more and more expensive, thankfully, by the day. And those expenses are not even compensated. So the winning party does not necessarily even get the zero sum that even after a 10-year litigation or a 5-year litigation that it deserves. So cost is a major factor that I think can improve and make litigants also realize that the more you go into litigation, you will have to pay up. So the faster you resolve your dispute, you are going to benefit at the end of the day yourself. Until there is a penalty involved, nobody changes their actions.
Thank you so much. I would now open the floor for question and answer session. So if anyone has a question.
Assalamu alaikum to you all. I hope you all are fine. My name is Mudassir. I am recently graduate student from SZABIST University. I have one question from all worthy panelists that in our country, as we saw that people hesitate to move on courts because of time-taking decisions and lengthy proceedings, so they believe on traditional dispute resolutions, which called as jirga system, where tribal heads punish them harshly against the human rights. So what is the main aspects to convert their people as alternative dispute resolution, as mediation, arbitration against traditional dispute system? Thank you.
The question that you're asking is actually jurisprudentially quite an interesting one. You're talking about a cultural legal system as opposed to a legal system, right? So you have a cultural system which deals with disputes, and you have a legal system which at times come and clash with one each other. Now, the problem that you've always had in Pakistan is that the decisions that are taken by some of these jirgas, I mean, I'm not saying all of them, usually comes into conflict with the law. Then what do you do? So you can't have two parallel systems running in one country, otherwise there is really no system then. In terms of enforceability, I would say the cultural system in certain parts of this country are probably easierly enforced than legal judgments. And that's really where the issue lies. Where do you draw this line? I don't think there's a real solution to this. I think that we, at the end of the day, are always going to be fighting this, and I think every jurisdiction has gone through this process, where you are trying to make social change through law and get past cultural issues. And this is just one more example of that. And I think that the only real way to do it is to statutorily say, this is the system, we're going to follow it, and we're not going to follow the other, because otherwise it's going to conflict with our legal systems. And that's what we have done in Pakistan. So, I mean, I think that's been solved to that extent.
Another alternate solution to that, perhaps, how about we do in areas where we have these area elders or vaderas, or whatever name that you may put to the person that the society or some parts of the society generally turn to for informal decision making. If such people can be made arbitrators by mutual consent and their decisions then incorporated into the legal framework, whereby then they are regularly involved with the legal system, and you don't take away their role of settling disputes, but you regulate it in a manner with the supervision of court.
Well, I think that you can understand that, but the issue is that what if that decision comes into conflict with the law?
Certainly.
And that's where the problem is. Most decisions that are made by jirgas are based on cultural norms and not on a legal basis. I'm not saying all. Some are based on law, but a large portion of them are based on cultural norms in that area. And if you have inconsistency throughout the country on the way that's applied, then you're going to have ad hoc systems just all over the place, and then you have no system.
If I could just add a thought. So very often the sorts of cases that make it to the newspapers that are settled through these informal means involve egregious violations of human rights. But there are also other cases which are ordinary civil disputes, which is land disputes and inheritance disputes and so on and so forth, which are exactly the bread and butter kinds of cases that do come to courts every day. And I think the solution could also lie in, as Ravi also alluded to, is actually incorporating this into the mediation and arbitration system that you're now developing. So, for instance, get these village elders into a mediation and arbitration program and give them the basics about what the laws are. And this is where you draw the line. You say, look, you can't have punishments like this. You can't have collective tribal punishments. But yes, you can decide, whose is what, that sort of a thing. So we should really use that.
Absolutely, yeah. Adil had a question. Yeah.
Thank you, Maham, and thank you to your panelists. My name is Adil Lalani. I'm a practicing litigator in Karachi. My question touches on arbitration and specifically an international aspect of it. We've taken steps to comprehensively revise the Arbitration Act. We have a wonderful bill which seems to be stuck in limbo, but it's a comprehensive step nonetheless. But on the other end of the spectrum, a lot of capital importing countries, of which Pakistan is one, have had increasing calls to roll back on bilateral investment treaties because there is this understanding that perhaps these treaties and the ISDS mechanisms contained therein disproportionately and negatively affect such countries in the decision-making process. So how do we reconcile those two positions when we are desperately seeking and desiring more foreign direct investment in our country, because justice and equitable and speedy justice is an integral part of that? So any of the panelists, thank you.
Get proper legal advice. I mean, that's the big one, isn't it? I mean, if you look at Pakistan's history in arbitrations, we've been appalling. Nearly every single arbitration that this Pakistan government has gone into, we've lost. So get proper legal advice, don't try and buy time, and fulfill your obligations. I mean, that's the whole basis of a contract, that's the whole basis of enforcement. And if you did that, then half of these problems really would not have come about. If you're talking in terms of a bias, in terms of the arbitration centers, how do you deal with that? Reinforce your own country to be, I mean, DIFC, Singapore, London International, you got international courts, commercial courts in Singapore. These have happened because there were confidence in those jurisdictions. So you've got to lay the groundwork for that. And the basis of that is get proper legal advice.
So I think based on getting proper legal advice, and I mentioned this earlier when I was speaking, one of our major sort of ways of conducting ourselves in international arbitration has been largely the way that we conduct our litigation here. And because that's how we've gotten away with it, and often litigation is not really just a tool to arrive at an actual resolution for a dispute. Sometimes it is actually there to put a plug stop, to try and avoid something moving forward, so that one party can take the benefit. Wo stay order aa gaya, your work is stalled. It does become an encouragement for that party to be able to win in whatever the nature of the dispute may be. Unfortunately, what we are now developing in Pakistan is a very reactive and remedial lens through which we are now adopting arbitration and mediation measures. And once that culture changes, and once we don't make exclusions such as we are trying to make in the Singapore Convention, if your state is going to step out, whereas the majority of your disputes, especially internationally, are relating to state-owned enterprises and other government entities, if the government itself is demonstrating a similar culture, if the government itself is choosing not to participate in those international forums. Those international forums are also not going to get a flavor of the demands of our disputes, get accustomed to the nature of our disputes and the considerations they do need to take from a Pakistan perspective or whatever other perspectives there may be in the context of international trade with a country like ours.
Yeah, thank you for your question. I think, at least to me, I detected that you were implying or you were alluding to the commentary on these bilateral investment treaties, that they are kind of what underpins them is a neoliberal economic order and that sort of a thing, where you need to have a protection and preservation of capital and protection in that sense. And although seemingly these documents are bilateral in that sense, in a sense that the Pakistani investor will have equal protections in those foreign countries, it only effectively works one way. I think, look, unfortunately, we learned our lesson a little bit too late, where for any and every government visit, just to celebrate it and have something to sign and have a ceremony, they'd go and sign a bilateral investment treaty without reading it, without looking at it, and without understanding its implications. Now, Pakistan was hit by the biggest sort of bilateral investor-state dispute damages ever. So I think we've learned our lesson now, and there is room to renegotiate these treaties. It can be done, and if the hope for Pakistan to attract foreign investment is predicated on how many bilateral investment treaties we've signed, that's not the case actually at all. That's not what a foreign investor looks at, because that's the last thing you want to be looking at. Oh, what if my entire investment gets expropriated or something? You look at generally what local investors are doing in the country, first and foremost. You say, well, even they're putting their money, it must be something there. You look at deregulation, you look at government sort of not involving itself in any and everything. You look at many other factors before you even think of bilateral investment treaties as a foreign investor to make a investment decision. So I think, yeah, if they're problematic, which many of them are, they can be renegotiated. And I don't think that should have such a negative impact on our prospects as an investment destination.
Thank you. Do we have any other questions? Yes, Singh.
Hello, Assalamu alaikum. My name is Faiza Sheikh. I am a mediator, and I taught the introduction to mediation over the summer here. My question actually goes to Justice Abdul Rahman with respect to the court annexed mediation that you were talking about. I've heard this referred to very fleetingly, so I'm really intrigued by it. But one thing you mentioned was the fact that it would be free,
yes,
if I've understood that correctly. I wondered actually first of all, why would it be free? Wouldn't it make more sense to have a staggered kind of fee system and also not burdening judges? Otherwise, how are you reducing the burden on the court overall? If you had mediators in place there, rather than judges mediating, and a staggered set fee, wouldn't that be A, economically more viable, and B, strengthen, ease the burden and make life a little bit easier?
So I understand where you're coming from, but let me just explain it to you in practical terms. When Pakistan first, and I'll answer your question at the end, so just bear with me. When Pakistan was first introduced to mediation in about 2005, it was the IFC who sponsored trainings over here. And I was certified as a mediator myself, certified as a mediator trainer myself, and then we started doing mediation trainings. The idea for that is capacity building and teaching the judiciary who was not acquainted with mediation as to what mediation is and what cases can be sent to mediation. Now, when you're talking about the Court Annex Mediation Center, that was part of the capacity building exercise. And I think it's important. The reason why was that there weren't enough qualified mediators to send these cases to. So we needed to send these cases and start this ball rolling. That being said, the core function of the judiciary is not to mediate. It's to adjudicate. And by assigning a judge to do this was part of the capacity building exercise. And quite clearly, that judge, being a judge, who's also certified as a mediator, cannot take a fee. And hence, that was the model that came about. Is it sustainable? I don't think so. And that's why, in the long term, the real only solution is to not have court annex mediation centers only. I mean, there are certain cases which will have to go to court annex mediation centers because the litigants will just not be able to afford it. But there will be others which would preferably go into private mediations with mediators like yourself and other mediators, and for which a fee should necessarily be charged as per their demands. I mean, Ms. Bashir was just mentioning about exorbitant costs. Yes, that's happening, but that's part of the market. So the more mediators, qualified mediators, you get more of a fee, it gets standardized, and you move forward. We're still at the capacity building stage. So we have to go down that. And I think in the long term, you will find that what I said right at the outset, you've got to make a decision as to whether you're going to follow a costs model or you're going to follow a pre-mediation model. And that has to be legislative. So.
Thank you so much. We have one more question. Yeah.
So my question goes more to the practical conducting of arbitration. I understand that there's a lot of jurisprudence now that states that procedure and Qanun-e-Shahadat, for example, don't apply in the way or in the conduct of arbitration. When you put that in juxtaposition with the capacity building points, competency points that were taken earlier in the discussion, do you think that right now, in Pakistan in particular, it is better to allow the system to continue without the intervention of, let's say, codification for how arbitration should be conducted or evidentiary standards? Or do you think that to build confidence in that system, that codification intervention is required? Which way would we say is a better approach for Pakistan in particular?
Who is this question addressed to?
Answer, but Hamza and I are colleagues and we can have an endless discussion over this subject at office. So I would prefer to, if Justice Saab can take this.
As far as arbitrations go, we have, I mean, the act that is currently pending does resolve a lot of what you're talking about. So I do think it's legislative. Ideally, I would like to see this out of the legislative system and more in terms of models like UNICITRAL or LCIA or those kind of institutions, because they're more practical. They're more pragmatic. Now, the minute you bring in a legislation, you're hidebound by the interpretations and it goes into debates and all of that. If you just get into a system which works practically, I think that works best in arbitrations. And I've done arbitrations, and some of them can be very, very time consuming. So if you get bogged down into legislation and all of that, it's better to avoid that. But I don't think that's going to happen in Pakistan.
Thank you. Thank you so much. I think none of you want to answer this.
I can happily take the cue, that's not a problem. Insofar as codification of the process of arbitration is concerned, I think it is helpful if certain basic guidelines are very much there. So if in the present model, the Arbitration Act says that the CPC and Qanun-e-Shahadat does not apply, the question really comes, is there no legal framework that will regulate the evidentiary basis on which the decision is to come about? And if there is some, then what is it? And I think the 2014 bill does propose a basic outline of those standards, although it does rightly reinforce that the rigors of the procedural law as applicable in the courts will not apply there. But the basic concepts of, to ensure that the principles of natural justice are definitely met. And that kind of environment by codification, I think that only helps arbitration as opposed to make it more procedurally stagnant?
Thank you so much. We can take one more question. I think there's one there.
Hello. Assalamu alaikum. Myself Farhan Ali and I am president of SZABIST University. Sir, my question is that in Pakistan especially, how much it is difficult and challenging for the implementation and executions of the ADR decisions, because unfortunately in Pakistan यहाँ पे Supreme Court के decisions की भी implementation बड़ी मुश्किल से होती है. तो as sir have mentioned that it's some sort of a private litigations. So who will be responsible for these decisions and for these execution and implementation of ADR, and how much it's challenging for especially for Pakistan? So kindly.
You see, the idea of a mediated settlement is that both parties agree. So if both parties agrees, then technically you should not have to go into enforcement. The query that you're asking is, once they've agreed, they change their mind. And if they change their mind, how do you deal with that? Well, the best way to deal with that is to probably go into remediation first. To turn around and put a clause in whatever agreement that you come, saying before you go into court to do any enforcement, if you want to change this, then you go in for a remediation. And then if that doesn't work, then you move towards enforcement. The enforcement problems are there. The enforcement problems will always be, let me give you an example. Suppose you go into a family mediation, like I've been saying, where you, before going into a case, you go into a mediated settlement. I'm not going to be able to file that anywhere to get a decree. And if I don't have a decree, then what am I enforcing? So those are the problems that you have. Again, these have to be statutorily addressed. It cannot be done any other way. If there is a dispute, that agreement becomes a decree, and yes, you have the same issues that you will have in enforcement of decrees, which is levels of appeal, time consumption. But hopefully the mediation process will take these cases out, so there's more time to do this, rather than to deal with the cumbersome aspects of all these cases altogether.
Thank you so much. This was an insightful panel discussion, and I hope this little efforts of ours can push the ADR in practical terms and also in theory. I would request our panelists to be seated now. Thank you so much.
We extend our heartfelt thanks to our panelists for such a thought-provoking and engaging discussion. At this point, it is my privilege to invite our chief guest, Honorable Justice Zafar Ahmed Rajput, Senior Peonage Judge of the Sindh High Court, to the stage for his keynote speech.
Before I start, I must admit that I have been benefited with the insightful discussion or panel discussion of learned panelists, and I am sure the audience too. Honorable Justice Abdur Rahman, Chairman ADR Committee, High Court of Sindh. Respected Ms. Patricia McKellar, Dean, Law Program, University of London. Respected Ms. Zainab Effendi Haqqi, Head of Department, Faculty of Law, SZABIST University. Respected Ms. Maham Jamali, Founder and Head of Central for Mediation, Arbitration and Conflict Resolution. Respected members of the legal fraternity, business community, and ADR practitioners, esteemed faculty members, dear students, ladies and gentlemen, Assalamu alaikum, good evening. It is indeed an honor to stand before you today as the chief guest at the launch of SZABIST Center for Mediation, Arbitration, and Conflict Resolution. I commend SZABIST University for this timely initiative. By establishing this center, you are not only broadening the horizon of legal education in Pakistan, but also responding to an urgent national need to ensure speedy and efficient resolution of dispute, protecting mainly commercial and business interest by avoiding costly, lengthy, and time-consuming court proceedings. So far, the legislation on ADR in Pakistan and provinces are concerned. We have Alternate Dispute Resolution Act 2017, Punjab Alternate Dispute Resolution Act 2019, Khyber Pakhtunkhwa ADR Act 2020, and additionally, the Code of Civil Procedure incorporated ADR through Section 89A and Order 9, which allow courts to refer cases to ADR methods with the parties' consent to expedite cases disposal. With regards to the theme of today's ceremony, turning the tide, reimagining justice through ADR, it is understood that we live in a time where our justice system faces immense work pressure. Courts across Pakistan are overburdened with millions of pending cases, many of them involving disputes that could be resolved outside of a formal courtroom. The result is not just delay, but a loss of public confidence. Justice delayed, as we know, is justice denied. Resolution of disputes through ADR is a significant shift in practice and perception. This is where ADR emerges as an essential complement to the traditional system of dispensing justice. Methods of ADR, such as arbitration, mediation, and conciliation, offer paths that are quicker and cost-effective. Although ADR is not a legal system, yet it has around the world become a set of processes and methods used within legal system to resolve disputes outside of formal court proceedings. It is functions as a complement to the traditional adversarial legal system, offering alternatives to achieve resolutions. From Singapore's International Arbitration Center to London Court of International Arbitration, vigorous ADR framework, the world has experienced that a courtroom should not need to be the only venue where dispute can be resolved. In our Sindh High Court, we have Sindh High Court Annexed Mediation Center also. Reimagining justice through ADR requires us to think beyond strict procedures. It invites us to see disputes resolution not merely as a judgment handed down by a court, but as a proper process of disputes resolving, where court proceedings can feel inaccessible. ADR enables parties to have more control over the outcome, leading to more flexible solutions. However, turning the tide is not without challenges. Many people still seek justice only in court decisions. They are unaware of ADR options. Overcoming this requires formal education, stronger laws to support ADR, and more awareness programs so that people know and trust these alternatives. In this context, I see SZABIST Center for Mediation, Arbitration, and Conflict Resolution playing a transformative role. It can serve as a platform of training and research which can provide skills to arbitrate and mediate effectively. Beyond this, the center can create awareness among the public and promote ADR methods. Ladies and gentlemen, to truly turn the tide, we must remember that justice is not a rigid concept. It evolves with society's need. ADR is not a rejection of the courts. It is a reaffirmation of the principle that justice must be swift and accessible to all. To the law students present here today, I would like to add for them that ADR is crucial for law students as it provides you with essential skill for resolving conflicts outside of traditional court, offering faster, cheaper, and more collective solutions than litigation. Understanding ADR enhances law students' problem-solving skills and equips them for a modern legal landscapes grappling the court backlog. It also improves access to justice by promoting amicable settlement and resulting community harmony. Before I conclude, I would like to congratulate SZABIST University on this initiative and pray that this center will grow into a leading institution of ADR reforms and innovation in Pakistan. Thank you very much.
We now request Vice President Administration and Acting President SZABIST, Mr. Imtiaz Qazi, Vice President Academics, Ms. Nasreen Haq, and Dr. Altaf Mukati to kindly come forward and present a token of appreciation to our esteemed panelists. Our chief guest, Honorable Mr. Justice Zafar Ahmed Rajput, please come to the stage. Honorable Muhammad Abdur Rahman. Sir? Sir? Mr. Meher Mustafa Qazi.
Thank you very much.
Ms. Alize Bashir. And lastly, Mr. Ravi Pinjani. We request all three of you to please kindly stay with us on stage. We now invite our panelists, faculty members, and distinguished guests to join us for a group photograph. Honorable Chief Guest as well. Kindly please come up on stage, Mr. Sarfaraz Metlo.
District Judges, Ms. Ambreen Aslam. Sir, please.
Thank you to all our esteemed guests for being a part of this important launch.
We hope that today's discussion will inspire a broader movement forward, embracing ADR as a meaningful tool of justice.
With that, we warmly invite you all to join us for networking and refreshments.